In bankruptcy, the plaintiff will file a complaint, and the complaint has to be clearly pled. It has to state what the facts are, what the problems are, and what the plaintiff is looking for. So the plaintiff files that along with a blank summons. Then the clerk of the court will issue the summons, and then the plaintiff serves a copy of the summons and the complaint on the defendant or defendants as the case may be. The summons will give a deadline by which the defendant must file an answer. And if the defendant doesn't file an answer by that deadline, then the plaintiff can ask for what's called a default judgment. Look, you didn't bother to answer. We're not going to wait till the end of the world. I want my judgment. Then the summons will also give the date and time for the first status conference. And that status conference will be before the bankruptcy judge assigned to the case. No later than 14 days before that status conference, the parties have to complete what's called a joint status report. And in essence, the joint status report says, well, this is where things stand. We anticipate that the trial will last so and so much time, that we'd like discovery to last so and so much time, and so forth. Then you appear before the judge, and the judge then will say, okay, where do things stand? Judge, having looked at the status report, wants to know in the interim, after you file the status report, maybe you worked out some kind of a settlement. If you did, then you're going to submit a 9019 motion with a copy of this proposed settlement to the court, and the judge will rule on it. If that isn't the case, then the judge will set a timetable. That timetable will include the time frame for discovery. Discovery is a process where each side gets to ask the other side for documents, for admissions of fact, for answers to questions. And the questions we call interrogatories. And if the other side, if one side wants to, it can also depose witnesses, that is, bring them into a place, swear them in, and ask them a series of questions under oath. So once discovery is completed, then you typically will show up again before the judge, because the judge will have set the next date for a status conference. Again, as with the previous status conference, you have to file a joint status report no later than 14 days before the status conference. And then the judge will say, okay, where do things stand? The way that this is structured does vary a little bit from judge to judge. You say, well, we just aren't seeing eye to eye, then the judge will plan on having a trial. Now, sometimes a judge will put a trial date in that original scheduling order. Other times, the judge might not put the trial date in, just say, okay, well, we're going to have the status conference after discovery to see where things stand. Somewhere along the line, before the trial, there will be a document that both sides have to file with the court called the pretrial stipulation. What goes into the pretrial stipulation is, in essence, saying, well, these are the things we can't agree on. These are the things we can agree on. So the things we can agree on, we're not going to waste time in court hashing through those things. Are we in the United States of America? Look, we all agree. Yes, we are. That's not going to be a disputed matter. Here are the things we don't agree on. These are the things we would like to have dealt with in the trial. So those things can be really quite voluminous. I remember the last one I did was something on the order of 100 pages. They don't all have to be that long, but sometimes they are very long. And then you'll have the trial. Now, generally in bankruptcy, you do not get a jury trial. Jury trials are as rare as hen's teeth in bankruptcy, although there is at least the possibility of a jury trial. There is a U.S. Supreme Court case called Grand Financiera that says that if a creditor, and generally it's the creditor that initiates the adversary proceeding, has filed a proof of claim in the case, it has, by doing so, come under the jurisdiction of the bankruptcy court. And so there is no jury trial. You have what's called a bench trial before the judge. But once in a great while, there is a jury trial. Otherwise, it's going to be before the judge as a bench trial. And then at that trial, each side is going to put forward its witnesses, put forward documentation to support its assertions. And then once the trial is over, then the judge, well, typically won't just rule right there from the bench, but will go deliberate with himself, herself to take a look at all the evidence and make a decision. Sometimes the judge rules the very same day. Other times the judge takes it under submission. That's the phrase that's frequently used here. And eventually the judge will issue a ruling, a judgment. And that judgment typically is what's known as a final judgment. Once that final judgment has been entered, then if either party wants to appeal, then that's the time to file the notice of appeal. And once you've done that, somewhere along the line, there will be a filing of briefs before the appellate forum. That's very much in a nutshell what happens in an adversary proceeding. There's usually a lot of paperwork that's flying back and forth. There may be motions that the court has to rule on. One common type of motion is what's called a dispositive motion. And that is a motion that, if it's granted, settles everything. It ends the case. It leads to a final judgment. A typical example is a motion for summary judgment, saying, look, even if everything in the complaint is correct, we as the defendant should still win. Or even if everything in the defendant's answer is correct, if we assume it's all correct, we still get judgment. Summary judgment motions are not granted all that frequently because of the extreme nature of it. And so a court is going to be very, very cautious about granting a motion for summary judgment. But that's clearly a dispositive motion. A similar sort of motion is what's called a 12b6 motion. This is under the federal rules of civil procedure. And what it says is, if everything is right in the complaint, there isn't anything here that is grounds for relief. There isn't a cause of action that's stated upon which the court can grant any kind of relief at all. So as a simple example, I remember having an adversary some years ago in which the plaintiff had filed the complaint, and all of the causes of action in the complaint were under state law. Now, bankruptcy is under federal law, and the bankruptcy court is a court of limited jurisdiction. Now, it's got very powerful jurisdiction within its realm, but it's limited jurisdiction. And if there are no federal causes of action whatsoever and nothing connected to the bankruptcy case, then there's no reason to proceed, because the bankruptcy judge does not have the authority to grant the relief that's requested. So I filed a 12b6 motion, and the judge granted it, and that was that end of discussion. So that's another example of a dispositive motion. Anyway, there's a lot more going on here than I've let on, but the question really seemed to be focused on just the major arc of what happens in an adversary proceeding. So if you're interested in filing an adversary proceeding, or if you're defending against one and you are in either Los Angeles or Orange or Riverside counties in the Central District of California, give me a call.